In relation to non-land related security, I mean, you could stamp nominally, so that about 500 naira, and then have that registered, your deed of release registered at the CFC. So other exemptions, they include instruments that relate to the government, excuse me, instruments involving ships, consular officers, cooperative societies, regulated securities lending transactions, and even your interbank payments and salary payments. So here we've done, so this is what I was referring to. We've tried to reproduce some of the instruments listed under the NTA as being stampable. So you see your mortgage, you see your conveyance and sale, and then you can see the exemptions and the person and the applicable rate. So I'm going to talk about some specific exemptions that I think people should be aware of. So the first one is capital duty on loan capital. So like I've been saying, you can do a secured lending or unsecured lending. In an unsecured lending, the applicable rate is 0.125%. So unsecured is just, I'm just giving you money, I'm not taking any security for that loan. I mean, people do that. And under the Stamp Duties Act, we used to have exemptions, which are, if it's a bank overdraft, you don't need to pay stamp duties on that. If it's a loan for less than 12 months, you don't need to pay stamp duties on that. Now, the Nigeria Tax Act has introduced a new exemption, which is on-lending arrangements. And there's no direction or guidance as to what exactly on-lending arrangements cover. However, we, in our experience, on-lending arrangements will involve, so I'm going to paint another scenario. So you have your lender, we have like an intermediary lender, and then the borrower. So, for example, your development finance institution, your International Finance Corporation, your African Development Bank, your Afrexim, they give money to a Nigerian commercial bank. And when they are giving that money to a Nigerian commercial bank, under the agreement, it's clearly stated that the funding that is being provided to that bank is to be on lent. It's for the purpose of borrowing that same money to, let's say, for example, small scale farmers. So a good example is, I mean, during COVID or years after COVID, we had a lot of this kind of arrangements. During COVID, we had a lot of this kind of arrangements where development finance institutions will they will give money to commercial banks in Nigeria and tell them that the purpose of the funding is to borrow that money to SMEs in Nigeria. So in that kind of situation, so we have two agreements in that situation. So the agreement between the International Financial Institution and the Nigerian Commercial Bank, based on the provisions of the Nigeria Tax Act, when that money is being provided to the commercial bank, they don't need to pay stamp duties because it is an on-lending arrangement. It is when the commercial bank now on-lends that same money to the final beneficiaries, so your SMEs or the farmers that the loan is primarily targeting. Those are the people that is when stamp duties will be paid. And again, I think this makes sense. It kind of does away with double taxation on the same income. So the next interesting one is a conveyance or transfer on sale. So conveyance or transfer of sale, that relates to the sale of land. So we used to have the exemption of if the property that you're selling or that you're buying or that you're transferring has a value of less than 10 million naira. I mean, in that situation, you don't need to pay stamp duties on the property. However, they've now introduced a new, I call it the 90% rule, and it relates to associated companies. So where the transfer is going to be between associated companies. So an associated company is a company that is holding at least 90% of the share holding in another company or through a third party, provided that it has been stamped upon the initial purchase. So that is, so we have two companies. So company A, company B, company C. So I own company A totally. Okay. Okay, so I own company A, 100%. Company A owns company B, 100%. 90% rule is saying that if company A bought that land, by the time company A bought that land under that deed of assignment, and you had already stamped that deed of assignment, by the time company A that owns more than 90% of the shareholding in company B decides to transfer ownership from itself to company B, you won't need to pay stamp duties on that instrument. So it's basically just as long as the property is moving within the same group. Remember, the important thing is the company transferring the real property to another company must own at least 90% of the shares in the other company that it's transferring the real property to. Again, this is another good cost-saving measure because I think most times people want to do intergroup transfers. This would help significantly reduce the amount of stamp duty payable. So we have this table that's just talking about fixed duties. So you can see simple agreements, you just stamp at the rate of 1,000 naira. One key one I want to talk about here is a guarantee. So as we can see from the screen, a guarantee is a simple agreement. A guarantee should be stamped at the rate of 500 naira. So I want to create like some nuance when you talk about it in relation to lending. So if I give you a loan of 50 million naira and then you got a guarantor to guarantee that loan, so saying that if you don't pay back that loan to me, I can recover the money from that guarantor. You won't just get that guarantee stamped at 500 naira without having stamped the original loan. So the facility agreement under which I give you that 50 million naira needs to first of all be stamped at the applicable rate. So if it's unsecured, so you stamp it at 0.125%. After you have stamped that, then the guarantee that is accompanying that loan can be stamped nominally at the rate of 500, at a fixed rate of 500 naira. So that's the distinction I'll just create there. Now to the interesting case I was talking about, and it relates to share transfers. We had talked about exemptions from stamp duty under the Nigeria Tax Act, and one of the exemptions that was clearly stated under the Stamp Duties Act and has been retained under the Nigeria Tax Act is that you do not pay stamp duty on documents relating to the transfer of stocks and shares. Now, in last year, so that's November 2025, right before the Nigeria Tax Act came into effect, the then the NRS, the Nigeria Revenue Service, as the NRS at the time, took Owando to court, to the Tax Appeal Tribunal in relation to certain transactions. So to give a bit of a background, between 2018 to 2020, the government was doing like a kind of audit on various transactions relating to oil mining leases that had been acquired within a 10-year period. So I think that was 2010 to 2020. And so the FIRS was instructed to basically go through their books, find out who had purchased or sold oil mining leases and all of that. And so that Owando had acquired some OMLs from ConocoPhillips under a share sale and purchase agreement. Now, the FIRS made a demand notice to Owando, asking them to pay about, I believe that was about $24 million as stamp duty that should have been paid on those share purchase agreements. So I want you to note that, so there were about 6 OMLs, and they did about 6 different share purchase agreements for each of the OMLs, because Owando used different entities. So they set up like SPVs. So you would have Owando OML 64 SPV. That was the acquiring party. So the FIRS, so Owando acquired this interest from ConocoPhillips in the 6 OMLs. So between 2012 and 2024, and the FIRS issued a stamp duty assessment of $88.2 million in 2024. So that stamp duty that the FIRS believes should have been paid, plus you remember the penalties I talked about, penalty of the 10% and the applicable NPR rate. So the FIRS asked Oando to pay $88.2 million, which is, I mean, that's a huge amount. So the FIRS's argument was that Oando had structured the deal specifically to avoid paying stamp duty on those documents. So, as can be expected, with that kind of huge tax liability, Oando appealed against the decision. And so Oando argued about a lot of things. They argued that they were not party to the agreement because they had used SPVs that they set up to acquire those assets. And what their key argument was assuming but not conceding that they were the ones that acquired. So I want you to note that Oando itself eventually acquired and became the legal owner of those OMLs. Oando now argued that those agreements should have been exempt. They're exempt under the provisions of the Stamp Duties Act. So note that the Stamp Duties Act, the exemption related to share transfers is also retained under the Nigeria Tax Act. So now to the argument. So the FIRS, in response, they argue that they try to create a distinction between what is an acquisition or a purchase of shares and what is a transfer of shares. I mean, so I have my reservations about the judgment, but objectively, I can't really see what the difference is. But the Tax Appeal Tribunal they mentioned some cases where a distinction had been created between what is an acquisition of shares and what is a transfer of shares. And according to the FIRS, because it was an acquisition of shares and not a transfer of shares, then the share purchase agreement should have been subject to tax at the rate of 1.5% of the consideration that was paid. Now, Oando pushed back on this, so there was a bit of back and forth, and then the Tax Appeal Tribunal came to a decision, and they held that Oando should have stamped those documents. So I'd said that instruments relating to transfer of stocks and shares were exempt. So this is a key decision because it's something that significantly could drive up the cost of M&A deals or your private equity deals, depending on what you're talking about. But one key thing to note is that the Tax Appeal Tribunal, so they based their decision. So I tried to quote what they exactly said, and which is that based on the combined reading of Section 59 of the Stamp Duties Act, where you have a contract or agreement under seal for the sale of any stock or marketable securities, shares like share purchase and sales agreements, they should be subjected to tax. So TAT referred to Section 59, but if you look at Stamp Duties Act, what they were actually referring to is Section 58. And I've highlighted the relevant parts, which is a contract or agreement under seal for the sale of any stock or marketable securities, including shares. They will be charged with the same ad valorem duty to be paid by the purchaser as if it were an actual conveyance on sale of the estate, interest, or property contracted or agreed to be sold. Now, let's just look at it so I wanted to note that the key thing here is that the decision was based on the provisions of Section 58 of the Stamp Duties Act, which talks about a conveyance or transfer on sale. Now, the Nigeria Tax Act, the question is, can this same judgment be reached under the Nigeria Tax Act? And the simple answer is, in our opinion, no. And so 3 key reasons. So the first one is the Nigeria Tax Act, it retains the exact same exemption, and it says all documents relating to the transfer of stocks and shares. It does not say instruments, it does not say a share transfer form. It says all documents, as long as that document relates to the transfer of stocks and shares, it's exempt from stamp duties. Now, the second reason is the 9th schedule to the Nigeria Tax Act. I think I'd shown that it specifically mentions the instruments that you should pay stamp duties on, and there's no reference to share or stock purchases or documents relating to share transfers. So what it means is like you just need to stamp that nominally. And then lastly, which is a very key difference between the Nigeria Tax Act and the Stamp Duties Act, is that the Nigeria Tax Act defines what a conveyance or sale means. Remember that the Tax Appeal Tribunal had based its decision on a section in the Stamp Duties Act that talks about a conveyance or transfer on sale. The Nigeria Tax Act clearly states that conveyance on sale means the transfer of interest in real property, being land and building only. So a conveyance on sale only relates to the transfer of interest in real property. So there would be no basis for the Tax Appeal Tribunal to come to the same decision because the conveyance and sale under the Nigeria Tax Act does not cover marketable securities or shares. So I think this is kind of good relief for taxpayers because as long as you're signing your share purchase agreement under the from 1st January 2026 to date, you should be fine. But if you signed it before 1st January 2026, there could be, it's something that we should be aware of, that there could be an issue with that if this decision remains the position under the Stamp Duties Act. We're not clear as to whether or not this decision is currently being appealed, but I think it's something that we'll be following over the coming months. So now, the conclusion. The Nigeria Tax Act has brought a significant change to how stamp duties operate. I'd mentioned how these huge laws and Stamp Duties Act was unnecessarily complicated, in my opinion, and now there's clarity. You could read the Nigeria Tax Act, look at the provisions of stamp duties, and have a good understanding of what you should and shouldn't do. And I believe that's a welcome development. Another takeaway should be that if your instrument is not specifically mentioned, like the deed of release that is relating to charging security, you should be pushing for that to be stamped nominally. And now there's a greater responsibility that is being put on taxpayers to just ensure that they comply with the provisions of the law and documents are stamped when they should be. So with this, we've come to the end of the presentation on stamp duties compliance under the Nigeria Tax Act. So I don't know if there are any questions, so we can take that before we round up. So Halima, over to you.
Thank you very much, Mr. Akintayo, for that insightful presentation. Also personally, I think it's a relief that, the stamp duties provisions has now been, put together with the NTA, coming from a law student perspective a few years back. Today's discussion has really highlighted the evolving stamp duties obligations of taxpayers in Nigeria under the new tax laws. Thank you so much. We'll now be moving to the Q&A session. There are currently no questions in the chat box, but I will just give a few more minutes to see if anyone in the room has questions before we close this out.
Okay. Thank you, Halima.
Just to mention that since we're in the Q&A session, you can actually also raise your hands if you would prefer to ask the question already. You can also still use the chat box. Okay, I think a question just dropped in the chat box. I will read it out, Mr. Akintayo. Okay.
Thank you.
So the question goes, just to clarify my understanding, although a deed of release is not expressly listed under the NTA, could it still be treated as a reconveyance subject to ad valorem stamp duty?
Okay. So thank you for the question. So I think I tried to create a distinction between what a reconveyance would be and yeah, between what a reconveyance would be and other forms of security. So a charge is a charge does not transfer legal title. So I'm charging my bank account, I'm charging my shares. Those things do not convey legal title, and they won't be covered under reconveyance because a reconveyance presupposes that initially you had conveyed legal title when you created the security. So in terms of your deed of release for a conveyance of legal title, so, and I mentioned that in relation to a deed of legal mortgage. So your deed of legal mortgage transfers legal title, you had stamped that. So when you're releasing it, that deed of release will most likely come under the reconveyance instruments mentioned in the Nigeria Tax Act. So you will need to stamp that ad valorem before you register it at the CAC, and the security will be released. But you compare this to a charge that doesn't transfer legal title, and your deed of release in that situation there's nothing under the NTA where you would, there's no classification, there's no instrument where you put that deed of release under. So you will not need to stamp that ad valorem. That deed of release should be stamped nominally. But in relation to a mortgage, to be a deed of reconveyance, basically.
Okay, thank you very much for the clarification. I think that's all the questions we have in the chat box. So at this juncture, I would just like to say thank you again to Mr. Akintayo for your valuable insights, and to all our participants for joining us today. Good afternoon, everyone, once again, and welcome to another episode of the UUBO Tax webinar series. We are delighted to have you with us. My name is Halima Adiola Bello, and I am an associate in the tax team at Udo Udoma and Belo-Osagie. Today, I'll be moderating this webinar session, which is organized by the Tax Practice Group at UUBO. Our tax team has extensive experience advising local and multinational clients on complex Nigerian and cross-border tax matters. We're also consistently recognized for our tax expertise by various leading directories, including International Tax Review and Chambers Partners. As we all know, today's Nigerian tax landscape has represented one of the most significant shifts in recent years. And due to these developments, the UUBO tax team has launched this webinar series to highlight the key changes introduced by the reforms and their implications for both resident and non-resident taxpayers. Today's session, which is the fifth in the series, will be focusing on stamp duties compliance under the new tax regime and the implications for taxpayers in Nigeria. Today's session will be delivered by our very own Mr. Oluwatobi Akintayo, a tax associate here at UUBO, and the session is scheduled to run for about 45 minutes, after which we'll be taking the question and answer session. On that note, just before then, I would like to let you know that you can drop your questions in the chat box during the course of the presentation, and they will be attended to after the presentation. On that note, I would like to hand over to Mr. Akintayo to begin the session. Thank you. Over to you.
Okay. Thank you, Alima, for the introduction. So, good afternoon, everyone. So I may be looking a bit, but I'm just timing so I can make sure we're all on track. So my name is Toby, like Alima said, and I'm going to be talking about stamp duties compliance under the new tax regime. So this is just an outline of what we're going to discuss today. So we're going to start with just telling you where we're coming from and where we are currently. So that's the evolution. Then we're going to talk about the types of stamp of duties under the new regime. Then we'll talk about the obligation to stamp duty, to stamp. We'll talk about timing, when should you stamp documents. We'll talk about the responsible party, so who has that obligation to stamp. Then we'll talk about why people should even bother paying stamp duty in the first place. Then, so we're going to talk about key changes under the new tax laws and how this affects stamp duties. So I want everyone to make a mental note about how, over the course of this presentation, we're just going to keep talking about what has changed, what has changed, what has changed. So even though we have like a specific section dealing with that, we're still going to, the changes cut across different things that we're going to talk about. Then we're going to talk about exemptions. I mean, everybody loves exemptions. You want to know which kind of instruments, which documents are exempted from having to pay stamp duties. And then we'll talk about something interesting, which is a decision that was reached by the Tax Appeal Tribunal last year as it relates to a particular exemption. And so we're going to analyze that in relation to the provisions of the Nigerian Tax Act. So let's proceed. Okay, so like I said, the evolution. So the question is, where are we coming from and where are we now? So I like to talk about, so when I talk about the changes under the new tax laws, I always talk about how, so I took tax in my final year while in the university, and I remember we used to have this big book of tax laws in Nigeria, a compendium, and it was voluminous because we had such huge laws. For example, the Stamp Duties Act, the one that's been repealed now, was enacted around 1939, and it had over 89 sections just addressing stamp duties. It had a lot of, so we had old penalties, so you had penalties for 20 naira, 15 naira. There were provisions that did not even reference electronic signing of documents, electronic stamping. So from 1939, we had the same Stamp Duties Act right up to when under the last administration, where we started having the Finance Act. So Finance Act 2019, 2020, 2021, 2023. So they made amendments to the Stamp Duties Act. So that's why now we have things about like you can electronically stamp your documents, you can get electronically signed document stamped, things like that. So this changes that the NTA, that the finance acts have made to the Stamp Duties Act over the years have now been codified in terms of they've now all been streamlined. So that's why you see we talked about a unified tax framework. So we have all a lot of the changes that were made by the various finance acts now incorporated under one law, so called the Nigeria Tax Act. So if you are looking for anything, so if you've been following our series since the beginning of the year, we've talked about how now we have 4 key laws. So the Nigeria Tax Act. So the Nigeria Tax Act has replaced all your value-added tax acts, your Stamp Duties Act, your Companies Income Tax Act. You find everything under the Nigeria Tax Act. So that is where, so if you're looking for provisions relating to stamp duties, you should start with the Nigeria Tax Act. And then we have, there are also some provisions, some relevant provisions under the Nigeria Tax Administration Act. So that's mostly in relation to penalties and trying to ensure compliance. So in all of this, where we're coming from is old laws, an old law that did not reflect current realities. And where we are now is a more modern law that recognizes that things have moved beyond hard copy signatures, getting everything in paper form. So that's where we are now. We are in an electronically driven age, and the NCA takes this into cognizance. So when we talk about stamp duties, there are different types of duties payable in relation to stamp duties. So the first one is what we're going to call, is what is called fixed duties. So fixed duties, that's just, how will I describe this? So this is something straightforward. I have a document. We're not looking at the value of the documents. It's just an agreement. So we typically refer to them as simple contracts. So you can see we reference some examples here, like your guarantee. So on the guarantee point, I'm going to expatiate on that a bit in a couple of minutes. But so you have your simple agreement, a simple guarantee. You just stamp it fixed, 500 naira, 1,000. So you have the one everybody's aware of, which is a form of stamp duty. Is when you make a transfer on your phone above 10,000 naira, then you have to pay stamp duties of 50 naira. So I mean, I know everybody's aware of that. Then you have ad valorem duties. So ad valorem duties, ad valorem just means according to the value. So that is okay. So I do finance, and I'm going to use a lot of finance examples to bring on my points. So I give you a loan for $50 million or 50 million naira. Ad valorem duty on that would be stamping a document at the rate of 0.125% of the value of the loan. So other documents other instruments that's subjected to ad valorem duties So we listed a couple of them. So you have your leases. I know many of us we sign leases and nobody's stamping those documents, but those things need to be stamped. I mean, if it's beyond a certain number of years, transfer of mineral assets. So the key thing when it comes to stamp duties is just what differentiates stamp duties from other taxes is we're stamping the document, we're stamping the transaction. So now, another key thing is obligation to stamp. So we're going to talk about timing first before we go to the responsible party. So in relation to timing, so this is we're going to talk about the situation before the Nigeria Tax Act, and we're going to talk about the situation now under the Nigeria Tax Act. So Section 125 of the Nigeria Tax Act is clear. So it says every instrument that is eligible for stamp duty must be stamped not later than 30 days after its execution by the person required to pay the appropriate duty. So there's some kind of nuance to this when you compare this to what was under the Stamp Duties Act, the now repealed Stamp Duties Act. So under the Stamp Duties Act, we used to have, so when you're stamping a document ad valorem, you need to stamp within 30 days where the document is executed in Nigeria, and where the document was executed outside Nigeria, we need to stamp within 30 days after it is received in Nigeria. So I believe it was 2021, we had this so when the Finance Act in 2021 came, the FIRS, the now NIRS, the FIRS then issued circulars, just to clarificatory circulars on this particular point about when is the document deemed to be first received in Nigeria. So I remember how if you, for example, so two parties, they sign an agreement, let's say both of them sign the agreement offshore, like outside Nigeria, until that document is received in Nigeria, the obligation to stamp does not arise. So that's under the Stamp Duties Act. And that FIRS circular was trying to define when the document is deemed to be received in Nigeria. So I remember there was wording to the effect that if you sign the document offshore and then you electronically transmit it to, let's say your lawyers in Nigeria signed, then your obligation to stamp arises from that point onwards. So that's something that should be noted. So under the NTA, what we just have is the NTA just states clearly that we should stamp documents within 30 days from the date of the execution in Nigeria. The NTA doesn't say anything about what happens in a situation where you execute a document outside Nigeria and then you bring it outside Nigeria. So it's silent on the timeline in relation to that. So another interesting difference between the Stamp Duties Act and the Nigeria Tax Act is in relation to what makes the obligation to stamp arise. And this is something that I believe over the next couple of months or the next few years will be something that tax practitioners and lawyers like myself would start considering and talking about. Because, for example, the Stamp Duties Act talks about stamp duty applying to any property situated or to any matter or thing that is done or to be done in Nigeria. You can compare this with the Nigeria Tax Act that just says stamp duty applies to any property situated in Nigeria or to any matter or thing done in Nigeria. So one, the Stamp Duties Act is used to be it's futuristic. It's talking about something to be done. We compare that with the Nigeria Tax Act that just says something done in Nigeria. So in a way, the Nigeria Tax Act is kind of more restrictive as opposed to the Stamp Duties Act that was very all-encompassing. Because, I thought of this analogy that I'm going to paint. So I go to the market and I enter into an agreement so this is a simple agreement with the seller to buy a bag of rice. So I'm going to analyze it under the Stamp Duties Act and then under the Nigeria Tax Act. Under the Stamp Duties Act, because the Stamp Duties Act says you need to stamp things done or to be done in Nigeria, as soon as I sign that contract, that obligation to stamp the document arises because, the contract just says, the contract has been signed, but until I actually pay for the bag of rice or the bag of rice is delivered to me, nothing has been done. We've just signed an agreement. So that agreement is still executory in nature. So when you compare this with what is under the Nigeria Tax Act, that same situation, when you sign the agreement, an argument can be made that obligation to stamp does not arise until when something is done. So in that case, until, let's say, for example, the bag of rice is delivered to me, or until I make payment for that bag of rice. So I believe this is something that we'll probably we'll see more of when people get more used to the laws. So our next slide is talking about responsible parties. So who has that duty to stamp under the law? We used to have this, so under the Stamp Duty Act, we used to have a very interesting provision that talks about, so there was nothing clearly stating who was responsible for stamping documents. We had a section that listed certain agreements, so it listed some agreements and specified that, oh, this person's, if this document is not stamped, this person's will be penalized. So tax practitioners needs to interpret that provision to mean, since the law is saying you will be penalized if you do not pay, if this document is not stamped, then we used to interpret it to say that those persons listed or parties mentioned are the parties responsible for stamping. However, the NCA is now very clear. It states exactly who is supposed to, who is the responsible party for stamping. So the parties include, so when you're transferring an interest in real property, it's going to be the transferee. So I'm selling my land to you. The person that is buying the land is the responsible party, is the party responsible for stamping that the contract of sale or the contract of sale or the deed in that situation. Where you're providing a service, so I provide my services to you under a contract, the beneficiary. So that means you are responsible for paying stamp duty in that situation because you are the beneficiary of the service. And then finally, when it relates to someone taking security in the transaction, so I've given you a loan of $50 million, and then you, as collateral for that loan, you've given me security over, let's say, your shares in another company or your bank accounts or your right to receive money under some agreement. In that situation, the person taking security, which is you, the lender, you are the one responsible for stamping that document. But having said this, these provisions do not rule out contractual arrangements that parties may enter into. So in a financing transaction, you could have your lenders not insist, but you have your lender say that the borrower is going to be responsible for paying the stamp duty. So it's a recognition that the lender has the responsibility to pay or to ensure that documents are stamped, but the lender is making sure that the borrower is making the required payments for stamp duty. And we can't talk about stamp duties in Nigeria without talking about upstamping. If we do a quick roll call of the guests in this room, how many people actually stamp their documents based on the provisions of the law? Very few people. I mean, other than the stamp duty that has been imposed on bank transfers, there's people, I mean, unless you're doing a financing of serious huge amounts and your lenders insist, most times people do not want to pay stamp duties. So upstamping is it's something that we use in financing, and it's basically a situation where you, so I'm going to use an analogy. So I have loaned someone 50 million naira. As security for the loan, the person has given me, let's say, has given me a charge over the bank account. And instead of paying stamp duty on the entire 50 million, we could have an arrangement. So that's between me and the borrower, saying that I, as the lender, I am going to be secured up to a certain amount. So that certain amount, so let's say I'm doing 20% of 50 million naira. So I've agreed to be secured up to 10 million naira. So what that means is, in the event of an enforcement, the maximum amount I can recover from that security is going to be 10 million naira. So we'll now have some kind of arrangement where the borrower could escrow the funds that will be required to upstamp that facility to cover 15 million. So typically you would have something like a trigger. So a trigger event, we typically call them like an upstamping event. So that could be maybe the borrower has defaulted on the loan, or there's been, sometimes you could even say the lender say at their discretion, they can choose to upstamp that facility. So if any of those things happen, the lender will just be able to take the money from we could call it an upstamping account. The lender can access the funds in the upstamping account, pay the stamp to cover the remaining 40%, and then recover the 50 million that be secured for 50 million. So one important thing to note when it comes to upstamping is that upstamping is not a direct creation. It wasn't a direct creation of the Stamp Duties Act. It's a creation of the Companies and Allied Matters Act. So the Companies and Allied Matters Act in Section 227 that's the basis for upstamping in financing transactions. And this practice has also been upheld by various court decisions over the years. I think one of them is like the Owen Boys case. So as it relates to the Nigeria Tax Act and the Nigeria Tax Administration Act, upstamping is still a valid practice because the provisions of the Companies and Allied Matters Act, that's where we derive the upstamping practice, is not inconsistent with the provisions of the new tax law. So upstamping is still a valid practice. Now, a very key question for me is why pay stamp duties in the first place? I mean, like I said, few people want to pay stamp duties. So the question is, why should I have to pay stamp duties in the first place? And I mean, so I've tried to arrange the reasons why people pay stamp duties in the order of priority. So the first key reason is evidence-related reasons. So that is, the Stamp Duties Act states clearly, the Nigeria Tax Act states clearly that failure to stamp a document that is stampable, so we have a list in the Nigeria Tax Act under the 9th schedule that lists the instruments that you should stamp. It states the rates, it will tell you whether it's ad valorem, it will tell you whether it is fixed, and then there's some exemptions. So we're going to get to a slide that just kind of gives you a high level of the various kind of instruments that you should stamp. So 3 reasons. So the first reason, evidentiary reason. If you do not stamp a document, it can't be admissible in court. So that is a document that is required to be stamped. If you do not stamp it, that document is not going to be admissible in court. So that is in relation to civil proceedings, because the NTA and the Stamp Duties Act, they both exclude documents in relation to criminal proceedings. And I think that makes sense to me, because if we're talking about the freedom of a person and a crime, it shouldn't be because documents were not stamped. That's why you can't tender those documents as evidence. So in multi-million dollar financings, it is vital that documents are stamped, because if you don't stamp your security document, you don't stamp your facility agreement, you can't tender them in court. So that is one key reason why people pay stamp duty. Now, the second one is kind of obvious, which is in relation to penalties. And I think I mentioned this at the beginning of the presentation, which is how the Stamp Duties Act used to have very small penalties. It used to have a penalty of 20 naira and then 10% of the unpaid interest. But the Stamp Duties Act has now kind of increased that. So there's about 100,000, and then the liability is also 10% of the unpaid duty. So if I'm supposed to pay, so when we discussed the case towards the end of this presentation, the tax liability, stamp duty liability there was about $24 million. So imagine having 10% of $24 million plus interest at the prevailing CBN MPC rate, MPR. So the MPR as of February was about 26%. That was the last one. I think reduced by about 50 basis points. And so the next monetary policy committee meeting of the CBN is going to be, I think, next week. So for now, we're talking about 26.5% in addition to 10%. So if you do not pay stamp duties and then you have a huge backlog, your liability is going to be huge. And so the last one is a very key reason: registrations. Like I said, in a secured lending, I've given you 50 million naira as a loan, and you've given me security as a form of collateral to back up that loan. If you do not stamp those documents, the CAC, that's your Corporate Affairs Commission, and the lands registry, they're not going to accept those documents for registration. And if those documents are not registered, then I am not secured as a lender. So it means I am an unsecured lender. And well, in the event of an enforcement, I have to go and battle with all the other creditors of that company. In the event of an insolvency, I have to go and battle and try to, when the assets of the company are sold in the event of an insolvency, my priority is, I'm not going to take priority over other unsecured lenders. So it is very important that documents, because if you don't stamp them, the other registries, like the CAC, the lands registry, they're not going to accept those security documents for registration. So these reasons are the reasons that deter non-compliance, and they can significantly impact on the outcome of the litigation. You can't tender a document in court. You are not fully secured because you've not registered documents at the relevant registry. And I mean, so under the Stamp Duties Act, we used to have that. There was an interesting provision about how so if you went to court, you didn't stamp initially, and then you went to court, the court could, if you explain to the commissioner, you could give a reasonable reason why you didn't stamp. They could do away with the penalties and let you stamp. But we don't have any of that under the NTA. It's clear. You don't stamp, you pay penalties. You don't stamp, you can't register your documents. So now we're going to key changes under the new tax regime, and I think I've already started going through some of them. So the first one is the timeline for paying stamp duty. I already talked about that. The Stamp Duties Act Stamp Duties Act used to talk about documents executed in Nigeria within 30 days, and documents executed outside Nigeria, you stamp within 30 days after they're first received in Nigeria. Now you compare this to what is obtainable under the Nigeria Tax Act, that just simply says you need to stamp your documents once they're executed in Nigeria, stamp within 30 days. It's silent on what happens where you execute your documents outside Nigeria. Then the second one is so clarifications as in relation to stamping of multiple instruments. So under the Stamp Duties Act, we had this practice. So there was a provision that we used to interpret to allow. So again, I've given you a facility of 50 million naira. You've given me a security. So let's say you've given me multiple security. So you gave me okay, so a charge over your bank account. You've given me a charge over shares. So and then there's the facility agreement itself. So because it's secured lending, you need to stamp at the rate of 0.375%. But you would be able to stamp you pick one of the security documents as your main instrument. You stamp that at 0.375%, and then the other documents will be stamped nominally. So what the NCA has done is state clearly that where you have multiple instruments relating to the same transaction. So like I said, the same 50 million naira loan, I have. So the same 15 million naira loan, and I have multiple security documents. I just pick one, I stamp that one as as the main document, and then the rest will be stamped nominally. Now, the next change it's an interesting one because I've started having conversations about this with some of the stamp duty commissioners. So it's in relation to the discharge or release of security. So I'll go back to my example, a 50 million naira loan. You've taken security over my bank account, and I have registered that security. I've stamped the security document, so that's your deed of accounts charge. I've registered it at CAC, and then so when you register it, it means anybody that does a search on your records will find out that you've already you've created security over that bank account. So it'll be difficult for you to use that same asset to create security again. So under the Stamp Duties Act, we used to have, so in the schedule that lists the different instruments, we used to have it clearly stated that where you are going to release security, it's called a deed of release, a deed of, you could use a deed of release, a deed of discharge, a deed of surrender, whatever nomenclature or name you want to give to it. Those security documents that you've registered at the CAC, you need to go and register another document. So that will be your deed of release or your deed of discharge, so that the CAC can clear that initial security registration from your records. So again, the CAC will not accept documents without them being stamped. So what we used to, under the Stamp Duties Act, those kind of the deed of release was subjected to tax at the rate of 0.075%. However, the ninth schedule to the Nigeria Tax Act does not contain anything relating to a deed of release, a deed of discharge, or a deed of surrender. So the implication of this is, if I register security and I wanted to release it, I don't have to pay stamp duty at the rate of 0.075% before I can release or discharge the security that I created in favor of a lender. So I think this is a key change because it significantly brings down the cost of lending generally. But what the Nigeria Tax Act mentions is a reconveyance of security. So a reconveyance of security. So a conveyance is where you've transferred legal title. So as it relates to most forms of security, so let's say your bank accounts, your security over receivables, your security over shares, those kind of things, you are not transferring legal title in those situations. The situation where you are transferring legal title is largely in relation to a deed of legal mortgage, because that transfers legal title. So in that situation, you would still need to pay stamp duties on your deed of discharge. So if the security you created was security over a deed of legal mortgage, you would need to do a deed of discharge, stamp it as a reconveyance, because you've transferred legal title to your lender when you created the security. So you need to transfer legal title back to yourself when you finish paying that loan. And so you stamp that at the rate of 0.375%.